Make sure I'm not frozen. Okay, we good. All right, cool. All right. Well, ruined my fabulous intro. I had a really good intro going on here. And how I was going to end that intro was as a person that been on trial many, many, many times. You have a good percentage in wins when it comes to being a trial attorney. Would you
I
agree
do.
with that?
Yeah, I mean, the facts are what the facts are. So yes, in terms of the number of acquittals that we've had, absolutely. I think I've been blessed.
And you want to give them a roundabout number?
Uh, so a few years ago, we were trying to figure out the number, and we can say confidently 40 acquittals. We just don't know how many more after that. It's one of those things where it happens in the moment. You celebrate it. Your client goes on his or her way, and you just sort of like move on to the next case. So it's over time we don't have we don't keep score like that. But a few years ago we thought, oh crap, maybe we should at least throw it out there so that people know the level of experience as well as the level of success that we've had. And we started keeping track. But the problem is, though, we remember a case, my assistant and I go, oh, wait, there's another case. We forgot about this one. So 40 is the confirmed number that we have so far. Yeah.
Okay. Now, which is a great deal, a lot. That's more than one a year since you've been an attorney, right?
Yeah, exactly. I've been an attorney 2002. So it's been a minute, 24 years.
Yeah, you got at least two a year under your belt. That's you average it out to that, right?
Yeah, I mean, I'd be doing well if I was playing in Major League Baseball right now, batting 300. You know what I'm saying? So that's
Right.
about right.
All right.
Yeah.
So what made you take on this case? Because
I
we've seen Carl Arnold, we've seen Michael Pandula, and they, for whatever reason, are no longer on the case. So what interests you in this case?
Well, it was sort of by, I don't want to say mistake, but it wasn't like I was looking for this case to try and represent Dwayne Davis. It was, I got a call from a colleague of mine, another attorney, and said, hey, there's this case, they're needing an attorney. Can you help out with it? Now, my problem is that as of last year in September, I stopped my criminal defense practice, which I had been doing since 2002. Because the personal injury side of my practice was growing in such a rate that economically it made sense to sort of shift all of my focus to the personal injury side and not the criminal defense side. So last year, I had bid farewell to the whole criminal defense side. I, spoke with DAs and said this was my last trial, and so forth. And lo and behold, I get a call and someone says, hey, can you help out? There's this, this case. It's called Keefe D, blah, blah, blah. And I had no idea who Keefe D was. I had no idea what the case was about. But because my friend had reached out and asked for my help, and I quite honestly was a little bored with my personal injury side because we were doing so well, I said, sure, I'll help out. So when I started looking at the case, that's when I realized, oh, wait, this is the Tupac murder case. Then it's a different understanding. Now it's to sit down with my people at the office and saying, hey, this is a case that I know is going to have a huge amount of expectation. Every case does, but because of the media coverage on this case, it would be even worse. So as a result, I sat down with my people at the firm and I said, look, this is something I think I ought to do. I understood that there was no money in it. There is no money in it, but I'm bored, and my personal injury practice is doing great. I have great partners. We're phenomenal on that side of the fence. So I said, why not? I got the time. Let's do this. And so 4 months ago, I sat down with my team, the people that have been successful with me, my assistant, my private investigator, and my person that helps me with my motion practice, and said, should we do this? And we all said, let's do it.
Are you afraid that this could, if you lose this case, it could damage your reputation? Because it's going to be a very big, high-profile case. Can you imagine Johnny Cochran losing the OJ case?
Sure, I could imagine him losing the OJ case.
Right.
I think when you look back at that case, there were all kinds of things that had to fall in the way that they did. I think the biggest error that the state put on that case, Christopher
Darling.
Dowden and Don and Marsha Clark, were the time when they basically allowed OJ to put on that glove.
Right.
Huge tactical error. And when you look at the racial tension that was going on during that time period, that basically was bubbling slightly below the surface, you had a situation where OJ's defense team looked at it from a viewpoint of, okay, let's harness all that. Let's harness all that distrust of LAPD. Let's harness all that distrust in our system and use that to our advantage. They still had to have things fall in their way. You know what I'm saying? They still have to have a villain, and that villain ended up being Mark Fuhrman, right? And him being racist, and the fact that he was, in the center of part of that case. Those are all things that have to fall in the defense's way in order for this case to go the way that it did. And in watching Johnny Cochran's performance, in terms of how he said it, the way he said it, and the facts that he had, some of the things were great. It's the mathematical issues with regards to the timing of what each witness said they heard, and the dog barking, and when did the person show up to the house to pick up OJ. Like, all those things were things that worked in their favor. So yeah, I think it's not just his eloquence and the way he was able to talk to that jury. It was also the factual issues that jury said, yeah, we don't feel good about this. That glove does not fit.
And let's not admit, LAPD does have a history of being corrupt. You know what I'm saying? So that wasn't foreign for a grade K. I mean, Mark Fuhrman. I'm thinking of grade Caden when I think of Mark Fuhrman. But but you got the Rampart scandal and things like that. So LA does have a history of being a little corrupt in the police department.
Absolutely. Rodney King is another one of those, momentous occasions that sort of framed everyone's perception of LAPD. And I mean, who carries around a camcorder back in those days and sits there and watches some type of, okay, well, that's you. So Chuck, that's you, right? I mean, it's like, but no, most people didn't have that technology. It's not like now where you pick up your phone and videotape. So to have that documented and have it out there was just sort of a way to smack people in the face and say, look, this is what's going on our streets and in our communities. And so, yeah, once again, when you have Johnny Cochran get up there, the words that he says are the words that I typically say. And, I don't say it in his way because that's his way and my way is a little different. But ultimately, at the end of the day, what he was arguing is that this is about facts. This is an idea that, hey, whatever the facts are is where the state needs to go. Not ought to go, not should go, but needs to go. Because facts are, at the end of the day, all that we have. That's the truth of the matter. And the problem is when you have a prosecution investigation that's not focused on fact, they're focused on a target. What they're saying is, here's our target, and we don't care about the facts. Whatever it is that we can fit in to help us hit that target is the only thing that matters to us. And that's where we run into the danger of prosecutions and police investigations that don't look at getting to the truth. They just want to accomplish the goal, the target of the person that they're going after.
Right. And in this case, unfortunately, Tupac has been a target of the police and maybe some government agencies most of his life. So it's hard because he's on both sides of the coin in this case right here. And which gets me to, want to ask you a few things. And you can tell me, what you could talk about and what you can't talk about. The first thing I want to ask you about is this rumor that the prosecutors had came to you and offered you a plea deal for Dwayne Davis.
All right. Let me preface my remarks first for your audience in terms of what I can and cannot say and why that is. So there's an ethical rule that every attorney has to abide by that deals specifically with pretrial publicity. And that rule really is a rule that is concerned with the idea of trying your case in the court of public opinion, right? That you get information out to the audience before a jury is actually formed, and that somehow you're communicating with the jury panel in an inappropriate way. Why is that important? Well, first and foremost is that what happens in court isn't necessarily what happens out on the streets and in our communities. The court is governed by what's called the rules of evidence, and the judge is the one who makes the decision as to what information the jury will hear and not hear during the course of a trial. Which means, if I just get up here and start talking about what I think the facts will show during the course of a trial, I don't know if the judge will agree with me on that. I don't know if a judge will rule in my favor on that. And so, in essence, what you don't want to do is throw out information that has not been vetted properly through the trial system, and the court has not approved of it before making comments. So as a result, that's why you don't really say anything about the details of a case. So in this case, you're asking about whether or not there was a negotiation. As of right now, I don't have a negotiation. So I have had, I have not had a negotiation. This idea that there was a 15-year offer that was out there for Keefe is completely wrong. I have not seen one. No.
Yeah, that's what these people out here false reporting. That's what they saying. But I did cover that yesterday and dispel that myth. But I'm glad that you are able to clear that up as well. But question, and
Sure.
to regard into what you just broke down about speaking on the case and trying to sway the public opinion. If what you just said is true, then I'm just purely speculating. I'm not saying that the prosecution is using anybody to do that, sway the public opinion. But how is Reginald Lilburn Wright Jr. able to testify in the grand jury and then go on YouTube and talk about the things that they stated that he shouldn't be speaking on in the grand jury? Because I read the grand jury and it states in there that you're not supposed to discuss anything in the grand jury publicly. And he's been doing that ever since he has testified in the grand jury. So I understand you respect the law, but how is he able to do that and talk about the case daily? And in the grand jury, it states that the people that testify in the grand jury are deliberately stated not to do that. Am I right?
You're partially right though, Chuck. Here's the issue. So when you're instructed by the grand jury to not disclose that you've testified at the grand jury, you do so up until the point that the grand jury becomes public, meaning that once the indictment has been filed with the district court and the arrest warrant's been issued, there's no secrecy there. It's only during the course of the grand jury's proceedings that you cannot talk about it at any point. And so when Reggie Wright decides at some point in the future to talk about what he testified to, of course they don't want him to talk about it before, because they don't want to give notice to the person that they're trying to indict that this is coming down the pike, right? So as a result, everything's in secret just to keep it away from the person that they're targeting. Yeah.
Well, he actually announced that Keefe D was getting indicted a couple of weeks before the indictment. I guess he knew because he testified in the grand jury.
Well, and at the end of the day, that's up to the state of Nevada to prosecute. I can't, that's their job. And obviously they didn't care enough to do it. So here we go, so, but right. Yeah.
Which that's why I feel like I'm not saying they put him out there to sway the public, but he's definitely swaying the public. Another thing that I want to ask you about is more recently there's this news report of there's been a bunch of files that have went missing. Could you talk about that?
So in one of the hearings that we had before Judge Kearney, the state had indicated to the court that there may have been some corrupted disks, some floppy disks that contained reports from Metro on those disks, and that they weren't able to recover what was on those disks. That was represented, I believe, by the state, and I don't know if it was the last hearing or the hearing before. Once again, I don't have them, so I don't know what was on them. Those reports, I don't think really matter to me whatsoever. I don't think it lends any credence to our defense. Now, what it does show, it just shows the sloppiness of this entire investigation. It shows that this investigation had more holes in it than me making pasta and taking whatever they call that to like get all the water out, right? It's like it was that bad of
Strainer.
information being out there. Yeah, and to me that's the problem with this case, right? It's not, there's no real case integrity, meaning that they didn't take the case and treat it the same way that they normally treat what's called chain of custody type of cases, where you investigate a case, you have evidence, you have to document that evidence. So at some point when you show that evidence to a jury, you can tell that jury, no one screwed with this evidence. This is evidence that literally, as if you were walking there yourself, ladies and gentlemen of the jury, and you found that evidence on the ground. That's how untampered with this evidence is. And you're doing that to show that jury that, hey, we're credible. Now, the problem in this case is that, over the years, so many books have been written, so many people commented on things. There's disclosures of like, subpoenas and copies of this and that and cading this. And, it's absolutely mind-boggling to me because I've never seen a case like that. And I think it's just because of so many eyes were on this case and so many questions that were left unanswered and so many people who cared enough about Tupac and wanting to know who did it, that there was so much immense pressure to get that file, those documents from people.
Right. Okay. So,
but I think
with that being said,
sure.
Are you prepared today to go to trial, or is this, something that they may have done to prolong things?
Look, man, typically what the state of Nevada will do is they'll tell me they've got it. Like, they'll come and be like, dude, your client can't get away from this one. There's DNA. Or, dude, your client can't get away from this because there's a fingerprint. In this case, this question you asked beginning about the offer, was there an offer to deal? I've not gotten one. And the reason why is because they don't have it. So in my, are we prepared to go forward? Absolutely we are. And I have a good team behind me. I've got good people that are working this case. And even the district attorney's office knows the qualifications of these people. They know we're not messing around with this case. And so as a result, we've been working, day and night. And when I told you in the beginning I was bored, yeah, I was bored. I don't have anything else going on except watching my personal injury partners do phenomenal, work with the firm. And so I have all the time in the world to sit here and go through the file just like the rest of my people. And we're ready to go.
Great. That's good because we tired of waiting. This thing been gets stalled.
And, at the end of the day, to me, the biggest victim here, and once again, no one's going to sit here and say, writing a book about someone's death and claiming all these things in it is a good thing. I don't think we would ever tell our children this is the way you should conduct yourself as people. But at the end of the day, Keefe being in custody for this long period of time is a tragedy. This case should have been tried within 6 months of the indictment. I mean, there was no purpose or reason why this case had to delay for 3 years to get to this point. And so us taking the case in April, just lend due respect to everybody involved, from Keefe to the system to even, quite honestly, Tupac. And that is, we don't want even the family of Tupac sitting out there saying, they said we have it, and then have him be in this position to not see the end result. And it's like for 3 years, everyone just languishes behind this case. And I think it's a huge travesty to everybody involved.
Yeah, and I wish rest in peace Afeni Shakur was here to see this. I got to meet her before and I've seen pain in her eyes. So, shout out to Sek and Aisha and Mo Preem and Talib and William and everybody else, in the family that's still alive. Because they finally, going to get their day to see what happens, and hopefully they get what they're looking for. What I was going to ask you next was, at this point, I'm sure you should have a witness list. Is the witness list in from the prosecution?
So the witness list, the prosecution has posted a witness list. It's online. You can get that information. It's public record. It's a little underwhelming, quite honestly. But it's their witnesses. That's the people that they say they're going to call as witnesses in this case. We're still formulating ours. And the problem with with the defense putting together a witness list, and it's the same problem with everything with regards to this case. The state of Nevada has the burden, right? So they're the ones who that have all the responsibilities of putting together a case in a way that they can say to a jury, "We've proven to you beyond a reasonable doubt." As a defense attorney, you're typically counterpunching. I'm usually like, I don't know if you ever remember De La Hoya fighting, great counterpuncher, even to some level, even Mayweather, right? It's a slip, it's a slip, it's a slip, and then it's jab, 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 right? He's never the aggressor. And so, in essence, when you're a defense attorney, you don't know what exactly they're going to present. You have a clue. You think you know what they're going to go with it, but sometimes you don't know. And in this particular case, what they've presented to us is what we have. We're still putting ours together. We have a deadline. The deadline is 5 days before the jury trial starts, is the deadline here. And so on that day, that's the day when everyone should be looking to see who's being called by who about, on this case.